Welcome back to the Legal Alternative Podcast. Me, Sam Pawson, joined as ever by Nils. Nils, we're back in person.
We're back in a new room.
In a new room. Yeah, we've both said it looks a bit like they're going to bring out some kind of salads and pasta for us in a minute, but we will crack on with the podcast in the new room, which is lovely. Lots of updates today. I think you've going to go first. I think quite an interesting update from you, and then I've got something on reasonable adjustments. So leave it over to you, Nils.
Yeah, well, I certainly find it interesting because there's a lot of history in our criminal justice system. And some of these proposed changes I find, I was going to use the word historic.
Yeah.
I think they are quite fundamental changes to a really old legal system.
Yeah.
Some of them I agree with. Some of them I'm less sure about. So on the 26th of February, what's called the Courts and Tribunals Bill was introduced to Parliament. And this was in response to David Lammy and indeed Sir Brian Leaveson's, I think is how you pronounce his name, independent review of the criminal courts. I say response. Obviously, a bill's not a response. It's off the back of those.
Yeah.
So the bill covers a series of measures that aim to primarily, in my understanding anyway, to reduce the Crown Court caseload, which is huge. We've got some clients accused of some really serious things. Who have been made to wait an awful long time to find out whether they're going to be found guilty or not. Aim to streamline the process and ensure that cases are dealt with in an appropriate jurisdiction and to reserve jury trials for the most serious cases. So just running through the measures. Some of the key ones: removing the defendant's right to elect for trial in the Crown Court for all triable-either-way offences, and with the decision being made by the court. I find that quite interesting. I'm not sure I agree with that. The requirement for a defendant's consent for the Crown Court to send a case back to the Magistrates Court will also be removed. A reform that I would be in favour of: reforming the appeals process from the Magistrates Court to the Crown Court by replacing the automatic right of appeal to the Crown Court from the Magistrates Court with a permission stage. So there wouldn't be a full rehearing. There would be a hearing on the issues for which leave then has to be given or granted. To support changes to the appeals process, legislation will be introduced to audio record in the Magistrates Court, which I would be in favour of. Introducing powers to extend the Magistrates Court sentencing powers up to 18 months or 24 months imprisonment for single and multiple triable-either-way offences. I think that's quite interesting. A new tier of the existing Crown Court, the Crown Court Bench Division, to hear triable-either-way cases likely to receive a custodial sentence of 3 years or less. That would be by a judge alone. Introducing trial by judge alone in the Crown Court for technical and lengthy fraud and financial cases. I think this is going to receive a lot of scrutiny. I think there's going to be a lot of feedback from a lot of different people on these changes. I think some of these changes I agree with. I particularly like the Crown Court the appeals sifting, if you like. I think that happens in other areas of the law. I think that's a good idea. I like the idea of a Crown Court Bench Division. I'm not sure that I like it that it's a judge alone, but I like that as a concept. I quite like a lot of these changes. I'm not sure I'm massively comfortable with the jurisdiction of the magistrates in terms of sentencing power being that lengthy. I think we've got a legal system that goes back a long way that has served us quite well. So some of these changes I really like. Some of them I'm less certain of.
For me, a complete lay understanding of this. For me, there's two major questions. One is jury, and then one is obviously the powers of each of those three types of court, whether it's the bench, the Crown, or the magistrates. All have differing issues. I think your jury one is, I think we have talked about in the previous podcast, that's much more of a matter of principle, whether you ultimately believe in jury trials or not. That's where you talk about the history. That's the kind of right to be tried by your peer is fundamental.
Yep.
But that, I suppose, that's what clogs it up, I'm guessing, in terms of speed and then the view is the judge alone will be quicker, I'm guessing.
I would have, yes. Yeah. And I think removing the right to elect for trial, that will naturally create space, won't it, in the Crown Court?
Yeah.
Because in theory, I'm guessing what the government is thinking is that there are people being tried in the Crown Court that ought not to be. Yeah. And that probably is correct, but I'm not sure I agree wholeheartedly that a defendant shouldn't have the right to elect for that. And I think that's a fundamental principle that we've built our justice system on that's actually worked quite well.
But I suppose without that one, the other reforms are slightly moot because if the view is people will always elect for a trial by jury, it would, under these proposals, have to go to the Crown then anyway. If there's no ability to hear it under the magistrates on the bench, I suppose that's the critical change.
It is, yeah. It's removing the defendant's consent and putting it in the hands of the court.
Yeah.
My worry is that, but from a tactical point of view, from a lawyer, selfishly, that's a really important tactic up our sleeve. Not tactic, I think, a right that people exercise. And I think that's something that, for me, to change that in response to what might be a short-term problem of the Crown Court being really busy. Yeah. It would be interesting, what are the, and I haven't looked into this, and should have done really for the pod, what are the proposals for actual investment in the Crown Court and the criminal justice system? Will this just clog the magistrates up even more?
And lots of parallels with what we've talked about from an employment perspective in the challenges. We both talk constantly about the challenges of the lack of funding within the courts and tribunal system, the problems that's bringing in terms of access to justice. Some of your clients you've referred to waiting, number of years. And again, in my world, 2 to 3 years for a tribunal claim. How does that impact access to justice? People's memories fade. To recall, instance, when you're putting so much weight on witness evidence in both of our fields, to then say, well, it's 3D and years down the line, there is an issue. And I suppose if I was being sympathetic to the government, I would say at least they're trying.
Yes, that's true.
I agree. It's that balance where what they're trying, is, if, as you say, if it is a short-term problem that can be fixed through technology, through investment in judges, in investment in the court buildings, which are into a decrepit state, is that a way actually of breaking a backlog without having to go to something quite drastic as the right to elect trial by jury? So interesting stuff. And as always with these political changes, it's how, but will the problem have been rectified, or will we have a different government by the time all of these things kind of come into force? Which is always interesting and, up for debate. But, I suppose at least it's been.
Yes, absolutely. So I think that's quite interesting.
Absolutely. Me too. Slightly different case for me. No kind of legal update from me in terms of legislation. I'm going to focus on a claim that's got a bit of press attention involving Sainsbury's. So this is a reasonable adjustments type case. And again, ones that we have talked about kind of historically on the pod, but I think again is always a really important reminder. And I'll be interested to get your take, Nils, but without preempting it, I'm guessing you're going to say, I'm surprised Sainsbury's fought this. will be my prediction of your answer, but I'll quickly talk you through the facts, which has got some wonderful pronunciations for challenges for me. So the case is, the claimant is Ricky Taylor versus Sainsbury's. Is the case reference. The employee claimant based in the Sainsbury's in St Albans. The pronunciation challenges I'll try my best on is Mr. Taylor's condition, which is ankylosing spondylitis, which from now on I'm going to call an autoimmune arthritic condition.
Right.
Get my tongue loose. Which is essentially a condition where the claimant experienced stiffness, trouble walking, arthritis in his knees in particular, especially when there's cold weather, which meant he found it difficult to walk, to kind of carry out his activities. Claimant was promoted to a custom and trading manager in 2022, and the contract that he signed at that point determined that as part of his work and his shift pattern, he could be asked to work any hours to meet the needs of the business, which included working weekends, late nights, and bank holidays. There's also a fact that will come relevant later that prior to his promotion, the claimant did have a number of high level of absences due to, again, problems with his knee and his ongoing disability. Matters come to a head where Sainsbury's then informed the claimant that he would need to work additional hours, including significant hours on the night shift as overtime. So a requirement to work what in evidence is shown to be an additional 10 hours per week. Claimant writes to the HR team at Sainsbury's to suggest that he can't work those additional hours because of his disability, and suggested a reasonable adjustment that he would be prepared to work 4 hours additional time. He was then called to a review meeting to discuss a probation period, not for his employment, but for his new position. And he was told that he had failed in that probation period for the promotion because he wasn't prepared to work additional hours. He was also then invited to a disciplinary hearing due to high levels of absence to do that. The claimant then makes a grievance about both the disciplinary and the failure to implement his reasonable adjustments, and obviously to fail his probation period. Grievance was dismissed. The view of Sainsbury's had dealt with it fairly, and he was disciplined and given a warning for his absence levels. The claimant then resigns in response to that, again bringing a claim in disability discrimination and a failure to make reasonable adjustments.
So construct
and a disability discrimination claim. Outcome of the hearing was that ultimately the tribunal upholds the claim. To note a few matter. They noted while Sainsbury's may have a policy on absence and a legitimate aim to manage absence, that the failure to put in those adjustments is a fundamental failing. They also indicate that his previous absences should have been disregarded for disciplinary purposes because they were related to a disability, i.e. his arthritic knee condition. They held that in the view of the tribunal, it would have been a reasonable adjustment to agree to those 4 hours rather than the 10 claimant was suggesting, and therefore upheld the decision and found that obviously the claimant had been discriminated on the grounds of his disability linked to the failure to make reasonable adjustments. For me, again, not a surprising decision, but one, again, I think is important to focus on. The fact that there has been some attempt by Sainsbury's to consider it, but just because you are considering reasonable adjustments doesn't mean that goes far enough. And where you're talking about quite in a broad term, relatively narrow changes between 10 and 4 hours, that still needs to be considered because they can make a difference. It's to me is a slight, I would call it a lack of imagination from such a huge organisation. Where the other thing I would struggle with is the question of reasonableness. That I would imagine that Sainsbury's in St Albans doesn't find it overly difficult to cover an additional 10 hours, additional 6 hours of employment. The number of employees that they will employ all on shift patterns, their ability to recruit additional people, to me would seem it would be difficult to suggest that his adjustment proposed wasn't reasonable. He wasn't saying that he couldn't work flexible. It was the amount of time due to a clear disability. So again, for me, not a particularly surprising decision, but one, again, I think really highlights for the clients listening, the need to look at these adjustments at face value and really focus on that word reasonable, which I think there's a clear failing to do here. I don't know your thoughts on this.
Well, I think when I did more employment law, if I were in that situation, I would be thinking, right, let's get a medical report. Let's work out somebody with that condition, how much absence would you expect them to have? Is the person above or below? And what does the medical report say? Is 10 reasonable? Where is it? So that's how I'm not saying that's the only way to deal with that, but that's how I would have dealt with it and just got somebody independent to say what is reasonable in both of those scenarios.
Whenever I talk about this case, I think it's, as you said, that balance between medical evidence and then a business analysis. If I was a judge there, I would be, I'm not suggesting that this is obviously a transcript of the case, that to really put the respondent to task there on that requirement, where's your business analysis, how can you not replace those hours? And they can point to clear evidence that says, medically this won't improve and this is why we can't accommodate, then they're on strong grounds. Again, one that again surprises you. There's no decision on quantum yet. One surprises you unless obviously what the claimant was asking for was completely unreasonable, that this got to a hearing, to be honest.
I think St Albans is a commuter town into London, isn't it? So I always think, the little Asda in Settle, just before the Three Peaks, I always think, how do you cover the shifts here in such a remote place that you would imagine it's so close to the capital and in a labourer market area that, as you say, I'm really surprised at how that's unpanned, actually. There we go.
Useful update as always, and off the back of your really interesting update. It's good to be back in person. Out the office. I am actually out the office next week. I'm going for a little weekend away, so in Tenerife next week. So that will be nice change. Although we have got a bit of sunshine here just as I am going away, so hopefully a bit more heat rather than a bit more sunshine would be lovely. Anything for you, Nils, in terms of out the office to report?
Well, just on that, a colleague who I won't name has also been to Tenerife recently. And he sent me a photo of O'Donoghue's bar in Tenerife. So we get everywhere.
We do. Yeah. I'll have to visit myself. I did tell him to leave me a note in somewhere in Tenerife to find. Yeah. All good. Seminar program now back up and running. Fantastic attendance. We had over 60 people in the Wakefield office last week, dealing with poor performance. We've got a flexible working seminar coming up in Huddersfield in March, and an April employment law update. All details put in the description, but also on the website for any of you who want to sign up. Brilliant. And that is it for this week. So we will be back in your ears and eyes shortly on my return. But otherwise, it's goodbye from me.
And thank you from me. Goodbye.